we are live. So again, welcome everybody. It's good to see everybody this evening. Seth, thanks for coming out again. We appreciate you being here. Let me just give you a little bit of a background story of who Seth is, okay? So one of the goals behind these webinars, and I've kind of mentioned this to each of you all, but really the goal is simple, is to equip each of you all to, build the lives you all want to build. And what we're trying to do is we're trying to bring in excellent professionals like Seth to help you in each of the areas. So we're super honored to have you here, Seth. So Seth is an attorney with Mattingly Ford. He's located in Louisville, Kentucky. He graduated with a bachelor's degree in history from Bellarmine University and went on to earn his Juris Doctorate from Indiana University of Bloomington. Is that how you say it, Seth? Juris Doctor. So Seth has practiced estate planning since the beginning of his legal career and is licensed in both Kentucky and Indiana. He also has licenses pending in Ohio and Missouri. Outside of his work, Seth also enjoys cycling, reading real books, like the ones that you can hold in your hands, right, Seth? I'm with you on that one. I appreciate that. So he also enjoys spending time with his family. So, and tonight, Seth is pretty much, he's offered his time just to come out and help us walk through wills, trust, some of these complex things that sometimes I think make us all a little worried if we talk about it. So I don't know about you guys, but sometimes people just put it off and they don't want to talk about it. And then when something bad happens, they find out they're not prepared. And I know all you guys want to be prepared. So thanks for coming tonight. And Seth, I'll hand it off to you. Take it from here, man.
Yeah, well, thank you all for tuning in and listening. My objective here is to have all of you walk away from this kind of talk having a better idea of how estate planning works and what the point of it is. And to be honest with you, that's probably the best place to start. Is why is it even important? Why does it matter to even talk about these things? And I had a mentor who always used to tell me that it was hard to get people to focus on estate planning because it brings up the three most controversial things in a person's life: money, their family, and dying. And when you get all those things collected in one pot, most people want to run away from it. And I get that. And so part of my job is to convince people that it's worth confronting now so you don't have to worry about it later. So the main pitch on why estate planning is important: two things. The first is that if you've got a young family, like if you're married and you've just had your first kids, or if you've got kids under the age of 18, that's where I'd put the cutoff. An estate plan is where you make your wishes about guardianship known. That's crucially important for a young family, because if something were to happen to you and you have minor children left behind, the court is not going to know what you wanted it to do with the kids. And so it's a big win. Now, it's important to always remember that there's no way for us to make the court do anything. None of these options are ironclad. So if you put somebody in your will saying that they should be the guardian of your children, and that person ends up with a drinking problem or just living a wild life, the court is always going to be free to say no to that person. But the parent's choice carries a lot of weight with the court, and as long as everything is generally okay, the court is going to pick who the parents want it. And you make that wish in your estate plan. So that's one crucial reason why you got to get on top of this. The other thing is that if you don't have any estate plan at all, you're what the state calls intestate. And that's basically consistent across every state. And the problem with being intestate is that you lose control over the distribution of your assets because you don't have anything set on paper. That means that the state's set of statutes have to take over and decide what happens for you. And that is a chaotic, expensive, stressful mess. Nobody wants to deal with that. It's the worst possible option for you and your family. I see it with clients all the time. Things always go way smoother when someone has some kind of an estate plan in place. So that's why that from a big picture perspective, that's the point of estate planning. And then there's other smaller points as well, like making sure that your assets go where you want it to go, controlling the distribution of your estate. All of that matters too. The next thing I think it's important to communicate is what exactly do we mean when we're talking about an estate plan? And there's four categories of documents that go into an estate plan. And I see a lot of people who have one or two of these, but very rarely do I see somebody who has all four. So I think it's worth touching base on what those documents are. The first category is a will or a trust. And that "or" is crucially important because you can't have both. part of my job with people is to help them decide which is the best for their family. But the key point here is you have to choose between the two. Now, wills and trusts have very similar objectives because they're both designed to distribute your assets if something happens to you, but they have very different ways of accomplishing those goals. And so that's our first category. The second and third categories kind of get lumped together because they function similarly. The second one is a financial power of attorney, and the third one is what's called a healthcare surrogate designation. That's basically a fancy name for what amounts to being a medical power of attorney. And I'll give you an example to explain how these two documents work. Let's say that you've had a shoulder surgery and you're going to be fine, but you're on pain meds, you're recovering, you're not making a lot of sense, and it's time to pay your property taxes. The financial power of attorney would let somebody access your bank accounts, write a check on your behalf so that you don't get a late fee or a delinquency on your taxes. That's how the financial side of things would work. Take the same example, but let's look at the medical side. For the medical side, let's say the doctors needed help figuring out what medicine works best for you or what kind of rehab plan you need. The person that you appoint on your healthcare surrogate designation works as your agent to make those decisions with the doctors. So the point of a financial power of attorney and a healthcare surrogate designation is to make sure that you have an agent in place to make decisions for you if you are sick. Now, that's a really important distinction because powers of attorney are only about what happens while you're alive. When someone passes away, a power of attorney evaporates. It turns into dust. It's worthless. So this is about caring for you while you're alive. And it's an important point because I see a lot of people who get laser focused on planning for a death. And that's great. We need to plan for deaths, but we also need to plan for every little issue that's going to arise before someone passes, because we're potentially covering, 30, 40 years of someone's life. So that's your second and third categories here. The fourth and final category of a main estate plan is something called a living will. And you've probably all heard about these because every time you go to the doctor, even for a simple checkup, the doctor is asking if you have one on file. And the living will is a bit different because it only applies in one very specific set of circumstances. That's when you are hooked up to all kinds of life support machines in the hospital and you cannot recover. So for example, the doctors have made a determination that you have no brain function. And if they were to disconnect you, you would pass naturally. The point of a living will is to make your wishes about life support known now while you're in good health, rather than having your family fight it out later. Because if you don't have a written living will, you again are relying on the state statutes, and the state statute is basically just a list of people in your life who have the authority to make that decision. So we're talking spouses are on there, parents are on there, kids are on there, and that concerns me for two big reasons. One, it is burdensome to put that decision on your loved ones. I deal with that with people a lot. It is a surprisingly traumatic thing to actually have to pull the plug on someone, to put it crassly. So I like to take that pressure off. The other thing is a legal concern, because you've got this list of people who have authority over your body. But what happens if you've got two people on the list who cannot come to the same conclusion? You've got two kids, or a parent is fighting with a spouse. That's the kind of argument that can split them up for the rest of their lives. And so it's better for all of us if we just close that door right now in your estate plan, and we do that through a living will. So that is your sort of 10,000-foot view of what an estate plan contains. Now, setting up powers of attorney is not that hard. All we have to really discuss is who do you trust enough to hold that power for you. So that most of my time spent with clients is not focused on that. The vast majority of my time with people is spent on deciding between a will and a trust. And if we had this little talk 5 years ago, wills were still way more popular because for 200-something years, wills were the main vehicle that everybody used. That has kind of flipped on its head, and now trusts are much more common. Like if you look back at my books for this past year, I believe I've done only 2 estate plans based on a will. So they really have become less popular. And I'll just tell you straight out, the thing that is driving that is when you have a trust that's set up correctly, your entire estate is exempt from probate. That's the big win on a trust. Now, you might be asking yourself, what exactly is probate? Probate is essentially a court proceeding that handles the distribution of your estate. And so it involves a couple of different steps that really give people trouble. First of all, it's a full court proceeding. So you have to submit paperwork with the court. You have to appear in court in front of the judge and swear a very serious oath that you are going to faithfully execute the estate. I mean, you literally stand there with your right hand raised and swear an oath. It's a big deal. Once you've opened the estate, you're responsible for collecting what's called an inventory, which is where you collect the information about all the possessions of the person who's passed away. So that's what probate looks like from like a general perspective. And there's kind of three problems that are driving people towards trust. One is just the complexity of what I just described. Very few people want to dump that on their loved ones because, you know, your loved ones are busy doing their own stuff. If something were to happen to you and your estate lands on their lap, they're going to have to reorder their whole life. So that's a problem. The other problem is that probate is required by statute to be open for a minimum of 6 months. That is because the courts want to give potential creditors a chance to file claims against your estate. And that may not sound like a huge problem, but 6 months is a conservative estimate. I know of many estates that have gone beyond that. I have a client friend who's actually going through their 10th year of probate. Like, it can get out of control quickly. And the reason why that might matter to your family is, let's say that something happens to you and your spouse in a common accident and your kids need your assets. They can't touch those assets until the probate court has cleaned them and given them a clean bill of health. So that delays the whole thing. So people are also trying to avoid that delayed timeline. The third thing that is driving people away from probate and towards trust is the expense of probate. Just like everything else, it has become much more expensive. And that's a combination of factors. For one, you're filing actual fees with the court, and they're usually multiple hundreds of dollars. But probate is a very complicated procedure with all of the filing all of these different types of documents. And so most people hire an attorney to represent them in court. And that's an expensive proposition. Personally, I bill hourly because I think it's more ethical, but my hourly rate for probate is $300 an hour. So when I do a probate estate, that bill inches up quickly. And I'd say a conservative estimate of legal fees in a probate estate is probably between $5,000 and $10,000 from me. But and I'm conservative. The Kentucky state statutes allow the attorney representing the estate to actually charge a percentage, and it goes up to like 6% right now. So let's say you send $1 million through probate and the attorney claims 6% of that. That's tens of thousands of dollars that you cannot send to your loved ones. It's going into the pocket of your representative. And so those are the three key factors that are driving people away from probate and into trust. Because like I said, when we started talking about this subject, trusts are the only way to ensure that none of your property goes through probate. And that's the other thing that's somewhat interesting is popularity of trust has been driven a lot by social media. That's not exactly helpful for me because I get a lot of people who have kind of strange ideas about trust. Like, they'll sit down and they'll tell me that they want to trust because they don't want to pay their taxes anymore. And I have to spend a lot of time telling them that is wildly inaccurate. But you know, as we sit here today, trusts have taken over. Wills are kind of in the backseat. Now, one thing about my philosophy on this is I'm not big on telling people that wills are worthless. I think there are scenarios where wills are actually the better option. And those scenarios would be, one, if you have a very complicated family and you're anticipating fighting. If you think people are going to give each other grief about the distribution of your stuff, you need the court and you need the judge to play referee on that. That's a very valuable tool in your back pocket. So if that's you, a will might be more appropriate. There's also the simplicity factor. Trusts are a lot more complicated to set up. They might require us to move assets around. It's a much more involved legal process working with me. A will is a lot simpler. You tell me what you want it to say. We put it down on paper. We throw it in a drawer and we forget about it until somebody actually passes away. And I think there's a lot of beauty in that simplicity. So if you were in your early 20s and you just got married and you don't have any kids yet, I would be perfectly comfortable putting you on a will until your family grows or until your lifestyle gets a little bit more cemented. So the bottom line there is there's still very much a place for wills in this kind of philosophy. Now, one important distinction here is that everybody has what are called probate assets and non-probate assets. There are certain assets that are exempt from probate simply by their very nature. Life insurance is the key example. When you have a life insurance policy and you have named a beneficiary, that policy will be paid out to the beneficiary outside of court always. And so that's a good example of a non-probate asset. Other non-probate assets would be checking accounts, savings accounts, IRAs, 401ks, cryptocurrency wallets, sometimes investment portfolios. But the key with those assets, they're only non-probate if you've named designated beneficiaries on the accounts themselves. So take a checking account. If you've got a checking account with 50 grand in it and it's in your name only, if you pass away, that is a probate asset and we have to launder that money through the court. If you pass away, but you've got your children named as your designated beneficiary, then the account automatically passes to them outside of probate. So that is your non-probate side of things. On the probate side of property are typically things with paper title. So when I say paper title, I'm talking real estate. I'm talking cars, RVs, boats, jet skis, some 4x4s, some golf carts have title. Some very high level works of art have title. Anything that's got a written paper trail needs to go into the trust as soon as you create it, because that is what will insulate those assets from probate. So that's your distinction between non-probate and probate assets. The other one other crucial thing I want to point out to you guys is there's a lot of misinformation swirling around out there about the distinction between a revocable trust and an irrevocable trust. The basic distinction there is that on an irrevocable trust, once you create it and sign it, it is set in stone, period. You cannot change the terms of it unless you lift mountains. Now, there's always a way out. So it's not truly set in stone, but you can get into some very dicey situations where to change your own estate plan, you have to open a civil lawsuit in court and get the judge to do it for you. That is wildly expensive and very complicated. That's how an irrevocable trust functions. A revocable trust means that you could get rid of it or edit it whenever you want without any complications. That's the main distinction. There's other way more complicated kind of differences between the two, but that's your kind of split. That's your key split between the two types of trust. I would tell you in general that irrevocable trusts, as the law sits right now, have lost their importance. They used to do, if you met with someone who did their estate plan like 10 to 15 years ago, I can almost guarantee you that they had an irrevocable trust. And the reason why irrevocable trust used to be very important was because if you put your assets in an irrevocable trust, they come out of your net worth, which means that you won't pay as high federal estate tax. And federal estate tax is what everybody is trying to avoid. It's the most cutthroat tax rate in the entire country. It's like a base rate of 40% just right off the top of everything you own. It's astronomically high. And it used to be that you paid estate tax if you were worth $500,000 or more. And so anybody who had $1 million had to shed $500,000 of assets to get under that threshold. And the way that they hid those assets was by putting them into an irrevocable trust. That doesn't apply to anybody anymore, because right now, if you're a single person, you don't pay federal estate tax unless you're worth $16.7 million. And if you're married, you double that. So unless you're astronomically wealthy, an irrevocable trust just does not suit you. And besides not being able to change them, the really tricky thing about an irrevocable trust is for it to function correctly, you cannot control it yourself. That's something most people don't realize. When you start an irrevocable trust, you have to appoint someone else to run it. And it can't be a spouse either, because if you appoint your spouse, the IRS sees that as being the puppet master. You and your spouse are considered to be the same person. So typically you have to appoint a child, or even further, a more further distant relation. Or if you've got a ton of money, you could appoint like a corporate fiduciary, like a bank or a trust company, but that comes with the downside of really high fees. And so that's kind of the breakdown of the difference between revocable and irrevocable trusts. One other nuance of irrevocable trusts is that they do have a place in elder planning for people who might need Medicaid. And the how irrevocable trusts function in that sense, you can shelter assets in them to make yourself eligible for Medicaid payments without getting liens attached to your property. So if you've got real estate or if you've got retirement accounts, you can shelter those in the irrevocable trust, make yourself eligible for Medicaid payments, and then Medicaid won't be able to claim the assets once you've passed. That is still a valid use of irrevocable trust, but that also does not apply to most people. That typically applies to someone who has very little in the way of assets, like their only asset is their house, and it's of a modest value, like $200,000-ish. So when you see irrevocable trusts floating around, pump the brakes, because they're not applicable to most people. But revocable trusts can apply to anyone. They're way more flexible. And the other beauty of a revocable trust is that it is considered a disregarded entity under the IRS code, which means that it does not have its own federal tax ID number. That means that it does not file a separate tax return. So if you had a revocable living trust, you continue to file your taxes through your individual social. So there's no complication of your taxing scheme when you have a trust. Everything keeps flowing exactly as it always has. That makes your life easier and saves you money. I tell people that a revocable trust is kind of like a Halloween mask. It's a disguise you're wearing to get certain benefits from the government, but underneath the mask, you're the exact same you always have been, and you can do anything you want just like you could before you created the trust. So yeah, I would say that that is sort of a broad sketch of what I typically go through during an initial consultation with people for estate planning. I know, Andrew, we were shooting for like 7:25, so I'm good to stop there if you want to transition into questions.
Yeah, absolutely. Seth, that's awesome, man. I think that's just, like I've heard you talk about this a couple times now, and I'm just always like, wow, this is a lot of information. It's a lot to take in. And honestly, personally, I've listened to it a couple of times now, and I still don't fully understand all the distinctions. So I appreciate you just coming here and giving us some time. Just so everybody knows, we do have a chat box. So if you think of any questions, you can go ahead and start dropping those questions. I'm gonna start asking just a couple questions here that I have primed for Seth. But as you think of your questions, feel free just to drop them in the chat, and then we'll have a time where I'll work through those as well. See, I'm looking around here, and I think most people, I think we're all under the age of 50. Some of us have families. Some of us are single. Some of us are trying to be forward thinking, right? Seth, what would you say is probably, and I know you don't want to get specific, but just for people like that, young families, singles that are looking to build, a life that they want to live and then protect their assets, what does that look like? What's kind of the next 3 steps, maybe?
Okay. Yeah. Anybody in those categories, this still works for you. We just have to do a little tinkering to make sure it fits your life. And so the way the process unfolds is the next step is to meet with me personally so that we can talk about the details of your life, and we'll come up with a plan together that suits it. If you are a young person who's single, the point of estate planning for you is to streamline the process and cut down on potential expenses. Because if you're single, you have no kids and no spouse, and you don't have an estate plan, the distribution of your assets is going to be wild. It is not going to go where you expect it to go. I'm telling you right now, it's going to end up as a funky split between your parents and your siblings. And most people don't want that. They want to exercise some sort of control about what happens. So if you're young, the main focus is how can you save money for the people left behind, and how can you control where your stuff goes? Even as like a stepping stone to building generational wealth. You might not be around anymore, but you might know who you want to pass things on to. If you are married, kind of similar thought process as if you're single, to be honest. And if you've got kids, it adds the layer of needing to address guardianship. And when you're married with kids, the stakes become a lot higher, because this is something that most people don't understand. Kentucky is a weird state because it has something called dower. It's the only state in America that still has dower. And it was basically taken out of English common law and dropped right into our statute. And it serves a good purpose because it's designed to prevent you from abandoning your spouse. Like, I'm all for that. That's great. But it makes estate planning complicated because you can't actually disinherit your spouse. And if you're married and you pass away without an estate plan, most people don't realize that the statutes found a way to make sure that not everything goes to your spouse. So your spouse might see you pass away and be expecting to take over your estate, and she's only going to get like half. The rest is going to be distributed between your kids if you have any. And if you don't have any kids, then it's a real free-for-all because other family members might get involved as well. So anybody in those categories, that's the point of all this. Yeah, no, that's good. And really, so Seth, then thinking through that then, so, they're trying to protect assets with is it really like, is it a will or a trust? And then of course there's different types of trust, or is sometimes the answer both? Just speaking generally. Yeah. That one, I see a question from Michael in the box anyway. So if it's okay, I'm going to roll this one into that because this is kind of the same type of question. Yeah, that's great. That's a common thing I deal with a lot. Estate planning does not necessarily, it's not necessarily about asset protection for the person doing the estate. You can do all kinds of asset protection for your kids. or your spouse, but you can't necessarily insulate yourself through your estate plan because a lot of this doesn't go into effect until after you've passed away. That being said, when you create a trust, especially if it's an irrevocable trust, that does create a little bit of insulation from liability. Like if you have a revocable trust and you get in trouble and it's a frivolous lawsuit, the lawsuit might not be able to pierce the trust. If it's a legitimate lawsuit, it's going to get through no problem. So that's how it would work with a revocable trust. If you have an irrevocable trust, that gives you much more ironclad protection from liability because the assets of the irrevocable trust you don't own anymore. So if someone's coming after you and your personal assets, the irrevocable trust is out of that pool entirely because you don't own it. So if you're super worried about a major lawsuit, that's maybe an option, but it's got all kinds of downsides about taxation and controlling your assets. And there also might be like timing components where you have to have everything set up enough in the future before the lawsuit. So it's hard to line that out correctly. Now, the question from Michael was specifically about how an LLC factors into this. And LLCs typically give you much more black and white protection from liability, but the common misconception on LLCs is that LLCs are meant to insulate you from actions of your company and the employees of your company. That's basically ironclad. So let's say you run a restaurant and part of your business is to deliver food. If you've got a delivery guy who goes out there and is delivering a pizza and he gets into a car crash, you're insulated from personal liability on that because he was acting it's called the scope of his employment is the legal term. And so that would give you total protection. The problem with LLCs is that if you create an LLC for yourself and you continue to do things yourself, there is no protection. So this comes up all the time for people who do rentals and real estate. If you have an LLC that owns your properties, but you are a handy person and you go and work on the hot water heater or you go and fix the floorboards on the porch and someone falls through there, if you did that act negligently with your own hands, you are guilty of that, period. The LLC does not matter. It will be pierced. And so the maximum reasonable amount of asset protection you can have is kind of three-tiered. At the very top, you've got a revocable trust. Your revocable trust owns your LLCs that own whatever other assets are related to the LLC business. Then on the LLCs itself, you carry very robust insurance, which includes umbrella policies. For the vast majority of people, that is the most practical solution to asset protection. Now, if you're somebody who runs a kind of risky life, or if you're the example that popped into my head, if you're a high-level trauma surgeon in an ER, you are running the risk of liability at a much higher rate than ordinary people. You might want to replace the revocable trust with an irrevocable trust. But that's not common for most people. Most people need to be in the revocable trust, LLC, insurance pyramid.
That's
okay,
good.
Michael had a follow-up there, which I'll go ahead and take too. That is the rub on this, Michael, because technically speaking, you can't. That's the whole point of this. So like if you create an irrevocable trust and you have to find someone somewhat remote from you to run it. A child typically is acceptable under the IRS code. But if you have a falling out with that kid, you're in a really, really difficult position because you don't exercise control over the trust. Your child decides how to run the trust for you based on their discretion. And so that's the real, it's a double-edged sword, and that side of the sword is quite sharp because if you don't think this through and pick somebody that you trust just absolutely, then you can be locked into a plan where you've lost control of your assets for no real reason. So that's ultimately the answer to that question. You can't guarantee that you keep control. In fact, kind of the point of it is that you don't have control.
Oh, that's good. That's good. So let me follow up with this. How about, so in your experience, you've probably seen, without giving names, you've probably seen a lot of problems, and a lot of times people have wished they'd done something. What are some of the most common mistakes that you've seen families make when they kind of avoid estate planning or put it off too long?
Yep. 3 popped into my head. Number 1, do it before it's too late. The hardest part of my job is when kids bring in their parents and their parents have either dementia or Alzheimer's, and nobody realizes how far it's gone. And I have to be the one to tell them your parent is no longer competent. That is a very difficult conversation to have, always filled with tears. It's awful. Don't let it go that far. Anybody I would say safely, anybody over the age of 40 has got to do this in some fashion. So that's one huge mistake. Don't wait too long. The second is if you have, do something with your cars. If you have a trust, make sure your cars go into the trust. If you don't have a trust, make sure that you have a co-owner on your cars. For example, if you're married, you and your wife should be joint on all of your cars. That way, if something were to happen to one of you, the survivor can take over without having to go through probate. I deal with probating cars all the time, and it is an expensive hassle that nobody needs to deal with. The third one is if you have investment accounts, particularly if they are stock accounts, make absolutely sure that you have some sort of designated beneficiary on that account. Here's your classic example. I'm dealing with this again right now. Somebody has roughly 360 grand in Class A UPS shares. So those are shares that they gained through employment. So Class A UPS shares are voting shares. They're extraordinarily valuable, but they didn't have anybody designated on the account. And so that has opened up a huge can of worms for us because not only is the account going to have to go through probate now, you are flirting with really bad capital gains issues because you cannot inherit Class A shares because you're not an owner of the company. So you have to take the Class A shares, convert them into Class B shares, then sell them on the open market. And we could have avoided all of that if the account had been set up on the back end with beneficiaries. So those are the three big pitfalls. Do something before it's too late. Don't ignore your cars because it's going to cost you, thousands of dollars later. And if you do have investment accounts, especially if they're dealing in stock, make sure you've got somebody named on there. Even if you don't have a trust, make sure you name someone.
Seth, talk to us about kids. So let's just say one spouse passes away, and let's say you had 3 kids. What happened to the kids? Or different scenario, what happens if both spouses tragically pass away in a car wreck or something? What happens to those 3 kids?
Well, there's kind of 2 levels to that. If you were talking about 2 spouses and one spouse passes away, there's not going to be much change to the kids because the surviving spouse will take over and they'll either continue to manage the joint trust or they'll have to deal with the estate if the person had no will or did have a will. So if one spouse dies, it's not that big of a change from an estate planning perspective. The more complicated issue is if they both pass. And that's when we're going to have guardians who are not the parents stepping in to take care of the children. So they'll have to figure out where the children are going to live. They'll have to go through the process of being appointed guardians. That's another actual court proceeding. You don't just write a letter and become guardians. You have to be approved and confirmed by the court. So that's a bit of a harrowing experience. And the other thing that we haven't really touched on is if you have a will or a trust, this is true for both of them, and it's drafted well, it should contain what's called a minor's trust. That's kind of a bad name for it because really the way to think about it is as a young person's trust. And the point of a minor's trust is that if you did leave young children behind and they inherited from you, they would not inherit outright. They would inherit through the trust, which would protect them from creditors. It would protect them from people who don't have their best interests at heart, and it would protect them from stupid spending. Because if you've got like a 16-year-old and you're about to leave him, $250,000, you're going to end up going to Thanksgiving and he's going to show up in a Ferrari. Like that just never works out because kids are terrible with money. So the idea of a minor's trust is you tie up the money for a certain number of years. Most of the time, my clients decide that the kids can go over once they're 30 because that's typically thought of as a fairly mature age. And once they become 30, then they can access their full estate fund and do whatever they want with it. But until they're 30, they can only tap into it for health, education, maintenance, and support. So like books for school, tuition for school, food to eat, a place to live, any kind of living expenses are doable. It's just frivolous spending that's cut off. So that's kind of a quick treatment of how kids factor in.
Yeah. Going back to just to follow up on the situation, 2 parents pass away. You said, people start writing letters to take the kids in and become their new guardians. Mm-hmm. Who makes that decision of who becomes the guardian?
Yeah, the court ultimately makes the decision, but the one of the things I mentioned when we first started was the point of doing any of this in a general sense is that you need to get your wishes about guardianship out there. If you've got a will, put it in there. If you've got a trust, put it in there. I do that all the time. And the point of that is when the court is trying to decide who should take over these kids, you can wave that document in there and say, hey, the parents have told us who they thought would be the best guardian of these children. And if that person is even remotely appropriate, the court is going to agree. You only run into problems if that person's got some sort of obvious issue that prevents them from taking care of the kids, like an unfit living situation or drug addiction or something like that. So yeah, you can't make the court do anything. The court will ultimately decide what's best, what's in the best interest of the children. That's kind of the legal turn of phrase. But if you've got it written on paper that here's who you wish would be the guardian, the court is going to obey that like 9 out of 10 times, if not more.
Yeah, that's good. That's good. And yeah, I mean, that's pretty crazy, right? It's like we see it in movies, right? Like Peter Parker, Spider-Man, or, we see all these crazy situations, but like, it happens, right? Tragic things happen. And ultimately, we, especially kids, I think kids is probably one of the bigger ones. We want to make sure that we have the right people taking care of our kids, if something tragic were to happen. So, if you were thinking through, here's another question for you. So if you're thinking through how to decide kind of the difference between, well, I guess let me back up. I've heard the terms also living trust and non-living trust. Can you kind of hash out those terms?
Yeah. Okay. We actually just talked about a good example. You'll typically see the legal terms for that would be you've got a living trust versus a testamentary trust. And the difference is a living trust is created while you're alive. So if you did a revocable living trust, that would be the full name of it. All that means is that you signed and created the trust while everybody was still living. So that's one side. A testamentary trust only goes into effect upon someone's passing. So when we were just talking a second ago about a minor's trust, that's a type of testamentary trust because that does not go into effect until the parents pass and assets move from the parents to the kids. At that point, your testamentary trust kicks in. So it's a difference of, is it created during your life or is it created when someone passes?
Awesome. That's helpful. So like kind of and you can, Seth, feel free to correct me. Kind of what I'm hearing is everybody needs something, right? I'm just going to make it super general. Everybody needs maybe a will, a trust of some sort. They need basically guidelines or instructions of what would happen to whoever, if they passed away, or even thinking about people who are older than us, maybe our parents, right? Our parents need something that gives instructions of where their assets, if there's children underneath 18, anything, there needs to be instructions for the court to be able to send out. And then there's ways to skip that 6-month probate through creative ways like trusts, basically.
Yep, exactly. A good way to look at it is there are 3 ways to pass away in a state. One is you've done nothing at all. That makes you intestate. That means that you're going to go through a version of probate that is way more complicated because there's no guidance for the court. The court's just going to fight it out through the statutes. They're going to have trouble figuring out who's in charge of your estate. They're going to have trouble figuring out how it's going to be divided. That's your worst case scenario because your time is going to be longer than 6 months and your expenses for the estate are going to be astronomical. So that's category number 1. Number 2 is you pass away with a will. That is a better option than the first one because at least you've got written instructions for the court. Your probate assets are still going to go through the probate process, so you haven't avoided probate, but you've got yourself locked into a version of probate that is way easier, way quicker, and way less expensive than the first type. So that's your second category people. The third category are people who pass away with the trust. And when you pass away with the trust, the main difference there is that if you've set it up correctly, meaning the assets are titled correctly into the trust, then there's no probate at all. The entire estate is wrapped up privately in the family behind the scenes. And so we've been talking about how you've got this 6-month waiting period for probate minimum. With a trust, I mean, if you've got everything lined up correctly, you can give me a call and I can wrap up a trust in 2 weeks. Like it's very simple.
Awesome.
Yeah, that's how I would break that one down.
Yeah. Well, it looks like Max has a question, and actually I'm going to kind of shift gears. So we've kind of talked about the basics for everybody kind of needs this basic ground. I want to kind of go to the next level, right? And Max's question is a good way. He's talking about, okay, so can you talk about the difference or the tax advantages between a will or a trust versus an LLC? So kind of thinking towards, once we kind of got the baseline, we're starting businesses, we're buying real estate. What are the tax advantages?
Yeah. Okay. This is another really common question. There's a number of taxes that can touch on estate planning and LLCs for that matter. We'll start at the very top. That we've already mentioned that's federal estate tax. what federal estate tax means is that you pay it if you're worth a certain amount. And like I said before, if you're single, it's roughly $16.5 million. If you're married, you double it. So if you're worth less than that, federal estate tax is off the table. Kentucky has no state version of estate tax. So as long as you're not super wealthy, estate tax is not a worry for you. So that's one thing off the table. Something else that frequently comes up is federal gift tax. What that allows is if you are single, you can give $18,000 of property to each person each year without paying taxes. If you're married, you get to double it again. So then you could do $36,000 to each person per year. If you go over that, you have to either pay the taxes or file special special gift tax returns, which is not ideal because they're complicated and expensive to prepare. In most cases, people wouldn't typically pay federal gift tax because you can use your estate tax exemption to cover your gifts. So let's say you made a $200,000 gift to your child and you're worth like $1 million. All you have to do is take that $200,000 out of your $30 million and that covers the gift. So now all of a sudden you don't pay estate tax unless you have $29.8 million, which still gives you plenty of breathing room. So most of the time, federal gift tax doesn't factor in as long as people stay within those bounds. The big kicker for estate planning is capital gains tax because there are huge savings here. The rule of thumb is that when you inherit property from someone, you get stepped up basis. And so just a quick rundown of how capital gains basis works. If you buy a property for $100,000 and you sell it when it's worth $300,000, you pay capital gains on the $200,000 increase, assuming it's not your primary residence. There's a safe harbor for primary residences, roughly $500,000 for a married couple. If you inherit that property, so let's say mom and dad left you a house. When they bought it, it was worth 100. When you inherited it, it was worth 300. You sold it for 300. You paid zero capital gains there. So whenever you inherit property, there's a huge capital gains savings potentially. And trusts can be used to even further increase that savings because thanks to dower, when you leave property to a surviving spouse, he or she will still be subject to a part of capital gains. But if you put it in the trust, then they're fully sheltered from capital gains as well. So capital gains definitely fits into this. There's two other ones that I should probably mention. Inheritance tax can sometimes kick in if you leave assets to someone somewhat distantly related to you. So think about cousins or further. If you leave things to your kids or your close relatives, inheritance tax does not apply. It's only when you're leaving something to a friend or a distant relative. So just keep that in the back of your mind. And then the last one is inheritance tax or income tax. And income tax doesn't typically fit into this because, like I said before, revocable trusts are disregarded entities. They don't file their own taxes. So you can just put that aside. If you have an irrevocable, then you would have to file specific taxes. And it's an important note because irrevocable trusts are typically taxed at a different rate than individuals. So you can end up paying higher taxes because you have an irrevocable trust. So that could be a negative consequence of that. Now for LLCs, in some ways, LLCs are kind of like irrevocable trusts because they do get their own federal tax ID number. They do have to file their own income tax statements. And you do have to be careful about how you run your books. Like if you have an LLC and you're making money through it, you want to make absolutely sure that that money stops in the LLC's bank account first before you distribute the profit to yourself and your partners. That can be a potential tax pitfall as well. As far as, and it also kind of depends on how many people are in the LLC. Like if you've got a one-person LLC, you can sort of dovetail it into your personal tax return. And that can save you money. And then also sometimes people will do what's called a subchapter S election. It's confusing, but that would mean that your LLC is actually an S corp. The confusion is that your LLC is not a corporation. It's an LLC that's elected for S corp status. That can also have tax implications to save you money depending on the size of your business and the type of business that you do. I'm not a tax attorney, so I'm not going to get into any more granular detail on that part. But yeah, that's just a quick breakdown of how taxes fit into this.
Yeah, no, that's good. That's good. I don't know about everybody. I'm sure everybody just caught all that, right? Like we get taxed on everything. We get taxed if we hold something. We get taxed if we make money on something. We get taxed if we sell something. We get taxed if we make too much, or if we have too much money in our account, we get taxed. If we give gifts to people,
Mhm.
we get gifts. If we pass away and give people an inheritance, like it's crazy, right? Like it is crazy. But anyways, it's the world we live in, and right, there are advantages. I've heard someone say it, basically the tax code's like 4 pages, and then everything else is cheat codes on how to basically keep your money.
It's accurate.
Yeah. So this is good, Seth. So I guess I don't know if everybody realized that, but like, yeah, if we give a gift of $18,000 to somebody, of more than that, right? I guess it's 36 if you're married, then correct me if I'm wrong, Seth. If I give a gift of 36,000 because I'm married, if I give something more than that, then I need to start paying taxes
Yep.
on that. It's like me, the giver of the gift.
Yep, is not the recipient. And like I said, the big downside of that most of the time is that you don't actually have to send a check to the IRS. You have to file a specific set of gift tax returns, which are difficult. They're fairly complicated, and you don't want to do that unless you have a really good reason to. Like, for example, what I would consider to be a good reason is if you are a parent and like your kid just got married and you're going to help them buy a house. That is a worthy use of this paperwork, because that would make that's worth doing, because you can't parcel out that gift into increments of $18,000. They need the money to buy the house now. So in that scenario or something like that, you bite the bullet, you file your tax returns, but you don't actually send the government a check because you took the money out of your state tax exemption. Because everybody's got this giant credit floating around out there, and you can tap into it for different things to reduce it, but cover your taxes now.
Yeah, absolutely. So I have 2 more questions left for Seth, but I want to open it up to you guys. Is there Max, Aaron, Turner, or Michael? Is there anything that's just kind of stewing? Feel free to drop it in the comments, or you can unmute yourself right now if you want to ask him just live. I'll give a minute for you guys to think. All right. If you think of anything, feel free to drop it in the chat. All right. Seth, we want to learn from you. We know that you work with some very wealthy people. Talk to us about wealth building strategies that we could, that implement, and maybe kind of the taxes is a good avenue into that. What are some of the things that the wealthy people that you work with, what are some of the ways they structure things in order to, keep their money and, keep building wealth?
Okay. Yeah, that's a loaded question. I'll name drop someone because it just occurred to me, and he would be very helpful for you. If any of you are looking for like financial advising, I work with a guy named Tommy Alvey at Dan Hart. He is an incredibly great guy, and he knows exactly what he's doing. And he has a fairly conservative approach to financial planning, but it's still pretty flexible. Like, there's lots of room to grow without risking yourself. So if you want to really dig into this, I would highly recommend you reach out to him, because I cannot recommend him enough. Things that I've seen and that I know of, here's one that's kind of weird. I'm seeing people, especially people with a lot of money, going away from sort of traditional investment vehicles and buying a lot of precious metals. I've done that myself. My dad has done that. I mean, my dad's got, I don't even want to say how much gold in the basement. Like, he's always been a huge proponent of precious metals, and that's something he instilled in me. And it's kind of become trendy again as we've watched the world get more and more volatile. And the idea of investing in precious metals is that they're supposedly more secure. So if you did have like a true breakdown of the international economy, you would still have something valuable in and of itself. So I've seen a lot of really wealthy people diversifying in that direction, just kind of as a side thing. I've seen, this is not going to be news to you guys, but real estate is still absolutely red hot. Especially if you can, if you can find rental houses in St. Matthews or Hurstbourne or J-Town and start spinning that off into like a little rental portfolio, huge. That's probably where most of my clients start with building wealth. Their first thing is that they find a reasonable rental to invest in, and then they come to me to help set up an LLC and an estate plan to protect that asset. So that's very common. And then the other thing I'll throw out there is when you start to build up something that's significant, you should start thinking about what's called a key man insurance policy. It's basically a variety of life insurance. And the idea is that when you run a business, especially if you have partners, you insure each other's lives. And so if one of the partners passed away, that policy would pay to the survivor or the survivor's spouse so that they could buy each other out of the company. That's a very, very powerful tool for managing a company. And a really advanced strategy is you can buy a key man life insurance policy for a huge amount of value, like $10 million, and then put it into an irrevocable life insurance trust. That takes the money out of your estate for federal estate tax purposes. So that, like, I've got a couple of clients right now who are north of $50 million, and that's a huge vehicle for them. So as you start building serious wealth, that's something to consider because it's a great protection.
Yeah, no, that's awesome. That's awesome. I don't know if you guys caught that, but like, think of it like this. Like, if I'm a business owner with Seth, we own the same business, he could take out a life insurance policy on me so that if I died, he would still have the support and the resources to be able to run the business. Is that fair, Seth?
Yeah. And it's especially useful if we're both married, because like your spouse might not have any idea how to run our business. So your spouse just got a $10 million life insurance policy. He or she can use that money to buy me out.
Yep.
That's
right. Yeah. So Turner had a follow-up question here in the chat. He said, what are the benefits and drawbacks of living and is that descendant? Yeah, descendant trusts.
Okay. I'll try to figure, I think I know what you're asking. I don't see that there's really a drawback to a decedent trust. Because most of the time decedent trusts are there to protect someone. So either young children or anybody who's got special needs. Those are two really good examples of who decedent trusts are for. I don't see any issues with those. As long as you have a good reason for protecting someone, that's what you got to do. It's kind of like, do you have this problem? If yes, here's your solution. There's not much discretion there when it comes to do you need this or not. So I'll put that one aside a little bit. The more interesting question is, what is a problem? What are the problems with trusts? And we've covered the problems with irrevocable trust, the loss of ownership, the complexity, the cost of setting them up, all of that stuff. But what about drawbacks to a revocable trust? Because they're not perfect. One of them is they're harder to set up for me. So your legal fees to create them are higher than they would be for a will. So that upfront investment is more. That's worth noting. The other thing too is, because trusts are so complicated, there has to be some diligence in setting them up correctly. Like if you came to see me, I would have you set up and you'd have everything you needed to get your cars into the trust. But I can't tell you how many people ignore me when they leave the building and never do it. And that blows a huge hole into the estate. So if you're going to do a trust, you got to be willing to jump through the hoops to finish the trust. And some people just don't have the time or the patience to do all that. And, cars are an easy one. You can end up with a bunch of assets that have to come into the trust. Like there are scenarios where the trust has to own every single one of your assets. So that means you got to transfer your bank accounts, you got to transfer your retirement accounts. That's a lot of time on the phone. If you transfer your checking account into the trust, you have to get new checks and you have to redo all your automatic withdrawals. Like that's a lot of work. And so I'd say that's the primary downside of a trust. You have to be willing to put in the work to run it, to set it up correctly. And then once it is set up, to run it faithfully for the rest of its existence. If you let things fall through the cracks with a trust, it's going to come back to bite you every time.
I guess the only other thing I could think of would be a drawback, and correct me if I'm wrong, Seth, but I've heard that basically if person A buys a rental property at $100,000, he dies, he passes it down to his son, person B, it's now worth $300,000. He would, no basis points, right?
Right.
Because it's a step up. And then he passes it down to his son, and now it's worth $500,000, steps up again because of the death of the person B. So there's no capital gains there. Person C, the grandson now sells it, and he has no capital gains. I guess what I've heard is if person A put it into a revocable trust, it got passed down twice, and then person C went to sell it, he'd have to pay $400,000 of capital gains tax. Tell me if I'm wrong.
I think that is one of the things that makes the distinction between revocable and irrevocable trust so important. If you have a revocable trust that owns a house and it passes on to your son, and then your son passes it along, that stepped up basis is maintained all the way down the chain.
Oh, that's good.
If you have it in an irrevocable trust, there are scenarios in which your capital gains stepped up basis is gone. So yeah, That I think that is the answer to that question. That's an
Okay.
irrevocable trust issue, not revocable.
Okay. Awesome. That's great. That's very helpful. So, all right, guys, it is 8. Any final questions before we sign off? Not seeing any. Seth, leave us with one thing. Leave us with, if you could just leave one piece of practical advice that you would give all these men who want to take care of their families and who want to build the lives they want to build, what would you encourage them to do? Just one thing.
I would tell you to be selfish about it, because a lot of times people get focused on how does an estate plan help their spouse or help their kids. That's great, and that's the most important thing, bar none. But there is a component here of taking care of yourself. And so you got to have documents in place, either POAs or a living trust to take care of you if you're sick. If you don't have those things and something happens to you, you're not going to be taken care of to the standard that you want and deserve. So do it for yourself and your family.
Awesome. Thanks, Seth. Appreciate it. Thank you all for joining. We appreciate your time. Thanks for coming out. Hopefully it was helpful. So did y'all have a good time? Thumbs up. Awesome. Cool.
All right. Thank you, guys.